Question 1. While analyzing the root causes of sequential problems in a high-value contract dispute, a buyer sues the seller for breach of contract after the seller fails to deliver specialized machinery as agreed. The buyer seeks specific performance, arguing that no substitute machinery is available in the market. The seller, however, contends that specific performance is not appropriate and instead offers to pay compensatory damages. Under contract law, which of the following is the most appropriate legal remedy in this situation? A. The court will grant specific performance because the machinery is unique and unavailable elsewhere. B. The court will only award compensatory damages as specific performance is never available for goods. C. The court will deny all remedies since the seller is willing to offer damages. D. The court will grant punitive damages to punish the seller for breach of contract. Answer A. The court will grant specific performance because the machinery is unique and unavailable elsewhere. Explanation. Under contract law, specific performance is an equitable remedy granted when monetary damages are inadequate. According to UCSS 2716, specific performance may be awarded in contracts for the sale of goods if the goods are unique or in other proper circumstances. In this case, since the specialized machinery is unavailable elsewhere, the court is likely to grant specific performance. Option B is incorrect because specific performance is sometimes available for goods, particularly when they are unique or irreplaceable, e.g. rare collectibles, custom-made items. Option C is incorrect because parties' willingness to offer damages does not preclude court from granting equitable relief. Option D is incorrect because punitive damages are generally not awarded for breach of contract unless fraud, malice, or other extreme misconduct is involved. Question 2. In a situation where formal requirements conflict with the urgent need for equitable relief, a plaintiff seeks a preliminary injunction to prevent a competitor from misappropriating trade secrets. The plaintiff presents evidence showing an imminent risk of irreparable harm but has not yet proven its case at trial. Which of the following best describes the legal standard the court will apply when deciding whether to grant the preliminary injunction? A. The plaintiff must prove a clear likelihood of success on the merits, irreparable harm, that the balance of equities favors them, and that an injunction is in the public interest. B. The plaintiff must prove beyond a reasonable doubt that the competitor is guilty of misappropriation. C. The plaintiff must show that monetary damages would fully compensate them for any harm suffered. D. The plaintiff must demonstrate that the defendant acted with actual malice in order to receive an injunction. Answer A. The plaintiff must prove a clear likelihood of success on the merits, irreparable harm, that the balance of equities favors them, and that an injunction is in the public interest. Explanation. A preliminary injunction is an equitable remedy that courts issue to prevent imminent harm while a case is pending. The standard for granting a preliminary injunction is outlined in Winter v. RDC 2008 555 U.S. 7 and requires the plaintiff to establish a likelihood of success on the merits, irreparable harm, if the injunction is not granted, that the balance of equities favors the plaintiff, that the injunction serves the public interest. Option B is incorrect because the standard of proof for injunctive relief is not beyond a reasonable doubt, but rather a likelihood of success on the merits. Option C is incorrect because monetary damages are insufficient when the harm is irreparable, e.g. loss of trade secrets. Option D is incorrect because actual malice is a standard used in defamation law, not a requirement for obtaining an injunction. Question 3. When developing a solution that must address opposing needs in a mass tort case, a court is determining the appropriate remedy for environmental contamination affecting multiple plaintiffs. The defendant corporation proposes paying damages while the plaintiff seek an injunction ordering a full cleanup of the affected area. Under Remedies law, which of the following factors will most likely influence the court's decision in granting equitable relief? A. Whether monetary damages would provide an adequate remedy or if an injunction is necessary to prevent ongoing harm. B. Whether the plaintiffs can prove that they suffered emotional distress beyond economic losses. C. Whether the court finds that punitive damages would better serve as deterrent than an injunction. D. Whether the defendant has admitted liability in prior environmental lawsuits. Answer A. Whether monetary damages would provide an adequate remedy or if an injunction is necessary to prevent ongoing harm. Explanation. In environmental law cases, courts often weigh whether an injunction is necessary to prevent continuing harm. The adequacy of monetary damages is a key factor in determining whether equitable relief, such as an injunction requiring cleanup, is appropriate. If damages alone would not sufficiently address the harm, an injunction may be granted. See Tennessee Valley Authority v. Hill 1978, 437 U.S. 153, where the Supreme Court prioritized equitable relief over monetary compensation. Option B is incorrect because emotional distress is generally not a decisive factor in determining injunctive relief, though it may be relevant for compensatory damages. Option C is incorrect because punitive damages and injunctions serve different purposes. Punitive damages are meant to punish, while injunctions prevent further harm. Option D is incorrect because prior liability in other lawsuits is not a direct factor in determining whether an injunction is warranted in the current case. Question 4. In a situation where formal requirements conflict with equitable principles, a court must determine the appropriate remedy to ensure justice while maintaining legal consistency. A plaintiff entered into a contract with a defendant for the purchase of a rare antique painting. The contract specified a price and delivery date but was missing a key term regarding insurance coverage during transport. Before the painting was delivered, it was damaged. While in transit due to an unforeseen accident, the seller refused to deliver the damaged painting, arguing that the contract was incomplete and unenforceable due to the missing insurance clause. The buyer sued for specific performance or, alternatively, compensatory damages for breach of contract. Which of the following is the most appropriate legal remedy? A. The court should deny all relief because the contract lacked a material term and is unenforceable. B. The court should award compensatory damages to the buyer for the difference in value between the painting as promised and its current condition. C. The court should grant specific performance, requiring the seller to deliver the painting despite its damaged state. D. The court should reform the contract to include a reasonable insurance clause and then enforce. Answer B. The court should award compensatory damages to the buyer for the difference in value between the painting as promised and its current condition. Explanation. A court will enforce a contract if the essential terms, price, subject matter, and parties are sufficiently definite, even if minor details are missing, ere the lack of an insurance clause does not invalidate the contract. The most appropriate remedy is compensatory damages. Option B is aim to place the injured party in the position they would have been in had the breach not occurred. Specific performance. Option C is generally reserved for cases where monetary damages are inadequate, such as in real estate transactions. However, forcing the buyer to accept damaged painting would be unjust. Reformation. Option D is used to correct mutual mistakes, but here the missing term does not constitute such mistake. Option A is incorrect because the contract is still enforceable despite its omission. Question 5. During an emergency response where multiple areas are impacted, the government issues an executive order limiting certain business activities. A restaurant owner sues the state government, claiming that the order resulted in a substantial loss of revenue and that they are entitled to damages. The owner argues that the government's action constitutes an unconstitutional regulatory taking under the Fifth Amendment. The government, however, contends the order was temporary health measure necessary to protect public safety. What is the most likely legal outcome in this case? A. The restaurant owner will receive full compensatory damages because the government's order substantially interfered with business operations. B. The court will apply the Penn Central test and likely rule that the temporary order does not constitute regulatory taking requiring compensation. C. The government will be forced to rescind the executive order and allow all businesses to operate immediately. D. The restaurant owner will be granted declaratory judgment stating that the order was unconstitutional, but no monetary relief will be awarded. Answer. B. The court will apply the Penn Central test and likely rule that the temporary order does not constitute a regulatory taking requiring compensation. Explanation. Under Penn Central Transportation Company v. New York City, 1978, courts evaluate regulatory takings by considering economic impact, interference with investment-backed expectations, and the character of the government action. Here, the government order temporary and enacted in response to an emergency, making it unlikely that the court would find regulatory taking requiring compensation. Option A is incorrect because economic hardship alone does not automatically trigger takings liability. Option C is incorrect because courts generally do not interfere with public health measures unless they are arbitrary or capricious. Option D is incorrect because declaratory relief would be unnecessary if the order was lawful exercise of government power. Question 6. In a case where multiple parties have different objectives, an environmental agency seeks injunctive relief against a corporation accused of polluting a river that supplies drinking water to local communities. The corporation argues that it has taken sufficient steps to mitigate pollution and that an injunction would cause significant economic harm, including layoffs and reduced investment. Which legal principle will the court most consider in determining whether to issue an injunction? A. The balance of equities, weighing environmental harm against economic impact. B. The adequacy of monetary damages to compensate affected individuals. C. The doctrine of res judicata, determining whether similar cases have been resolved previously. D. The rule against perpetuities, assessing whether the injunction would impose an unreasonable restraint on future business activities. Answer A. The balance of equities, weighing environmental harm against economic impact. Explanation. Courts consider balancing of equities when deciding whether to grant an injunction. The plaintiff must show that the environmental harm is substantial and irreparable, while the defendant may argue that the economic impact outweighs the need for immediate injunctive relief. Courts often apply the Winter v. ADC 2008 standard, which showing 1. Likelihood of success on the merits, 2. Likelihood of irreparable harm, 3. Balance of equities, and 4. Public interest considerations. Monetary damages, option B, are inadequate in environmental cases where harm is ongoing and difficult to quantify. Res judicata, option C, is irrelevant unless there is a prior judgment on the same claim. The rule against perpetuities, option D, applies to property law, not equity relief. Question 7. When scaling up operations that experience significant contractual breaches, a company finds itself in dispute over liquidated damages. The company had included a clause in its contract stating that any delay beyond the agreed timeline would result in a daily penalty of $10,000. A subcontractor challenges the clause, arguing that it constitutes an unenforceable penalty. Which of the following is the best analysis? The liquidated damages clause is enforceable if it is a reasonable estimate of actual damages at the time of contracting. B. The clause is automatically unenforceable because it imposes a fixed monetary penalty. C. The subcontractor must show that actual damages were lower than the liquidated amount to invalidate the clause. D. Courts never enforce liquidated damages provisions in contracts involving business transactions. Answer A. The liquidated damages clause is enforceable if it is a reasonable estimate of actual damages at the time of contracting. Explanation. Under contract law, liquidated damages must be a reasonable estimate of potential losses at the time the contract was formed to be enforceable. Courts apply the two-pronged test from restatement. Second of Contracts SS 356. 1. The damages must be difficult to estimate at the time of contracting, and 2. The amount must be reasonable forecast of harm. If the clause is punitive rather than compensatory, it will be struck down. Option B is incorrect because liquidated damages are not automatically unenforceable. Option C is incorrect because the burden is on the party enforcing the clause to justify its reasonableness. Option D is incorrect because liquidated damages clauses are commonly enforced in commercial settings. Question 8. In a situation where formal requirements conflict with equitable principles, a court must determine the appropriate remedy to ensure justice while maintaining legal consistency. A property owner enters into a contract with a construction company to renovate a historic building. Midway through construction, a local zoning board issues a new regulation restricting modifications to historic buildings, preventing the company from completing the project. The property owner sues for breach of contract and demands full performance or monetary damages. The construction company argues that performance has been rendered impossible due to the new zoning law. What is the most likely legal outcome? A. The court will hold the construction company liable for breach of contract and award full compensatory damages. B. The court will excuse the construction company from performance under the doctrine of impossibility. C. The court will require the construction company to complete the project despite the zoning restriction. D. The court will award partial damages but allow the company to avoid full liability under the frustration of purpose doctrine. Answer B. The court will excuse the construction company from performance under the doctrine of impossibility. Explanation. The doctrine of impossibility applies when an unforeseen event makes contractual performance objectively impossible. In this case, the construction company cannot legally proceed due to new zoning restrictions, making performance impossible rather than merely difficult. Courts typically excuse parties from liability in such cases. Option A is incorrect because breach requires fault and the construction company is not at fault for the change in law. Option C is incorrect because courts will not order an illegal act. Option D is incorrect because frustration of purpose applies when performance is still possible, but the underlying reason for the contract no longer exists, e.g., renting a space for an event that gets cancelled. Question 9. During an emergency response where multiple areas are impacted, the government issues an executive order limiting certain business activities. A manufacturing company that produces medical supplies is required to halt production of non-essential items and shift to producing ventilators under a federal mandate. The company argues that this constitutes a taking under the Fifth Amendment and demands compensation. What is the most ruling in this case? A. The government must compensate the company for all losses because the order amounts to a regulatory take-in. B. The court will apply the Penn central test and likely rule that the mandate is a valid exercise of government power under emergency conditions. C. The company will be able to sue for damages under the contract clause of the U.S. Constitution. D. The government will be forced to rescind the order if it does not offer just compensation. Answer. B. The court will apply the Penn central test and likely rule that the mandate is a valid exercise of government power under emergency conditions. Explanation. Under Penn Central Transportation Company v. New York City, 1978, courts balance economic impact, interference with expectations, and the character of the regulation. In emergencies, courts often uphold government actions that serve public welfare. Option A is incorrect because temporary emergency orders rarely constitute a taking requiring compensation. Option C is incorrect because the contract clause limits state interference with private contracts but does not apply to federal emergency mandates. Option D is incorrect because the government is not required to rescind emergency orders unless they violate constitutional protections. Question 10. In a case where multiple parties have different objectives, an environmental agency seeks injunctive relief against a corporation accused of polluting a river that supplies drinking water to local communities. The company argues that it has implemented measures to reduce pollution and that shutting down operations would cause economic hardship. Which legal standard will the court most likely apply? A. Strict liability, holding the company liable regardless of fault. B. A balancing test, weighing environmental harm against economic impact. C. A negligence standard, requiring proof that the company failed to exercise reasonable care. D. The company will be exempt from liability if it can show it acted in good faith. Answer. B. A balancing test weighing environmental harm against economic impact. Explanation. Courts apply balancing tests in environmental cases, considering the severity of harm and the feasibility of alternative measures. The Supreme Court in Winterthur, AODC 2008, emphasized that courts should balance public interest factors. Option A is incorrect because strict liability applies mainly in hazardous waste cases. Option C is incorrect because proving negligence is not always necessary in environmental law. Option D is incorrect because good faith does not automatically shield companies from liability. Question 11. When scaling up operations that experience significant contractual breaches, a company finds itself in dispute over liquidated damages. A software vendor agrees to deliver a custom-built system by June 1 but fails to meet the deadline. The contract includes a $5,000 per day liquidated damages clause. The vendor challenges the clause as an unenforceable penalty. Which legal principle applies? A. Liquidated damages are enforceable if they reflect a reasonable estimate of potential losses. B. A clause is automatically void because it imposes a monetary penalty. C. The client must prove actual damages exceeded the liquidated amount for the clause to be valid. D. Courts do not enforce liquidated damages clauses in commercial contracts. Answer. A. Liquidated damages are enforceable if they reflect a reasonable estimate of potential losses. Explanation. Liquidated damages are enforceable if they reflect a reasonable estimate of losses at the time of contracting. Courts apply a two-part test. 1. Whether actual damages were difficult to estimate, and 2. Whether the amount was a reasonable forecast. Option B is incorrect because liquidated damages are not inherently unenforceable. Option C is incorrect because proving actual damages is not required. Option D is incorrect because liquidated damages clauses are common in commercial contracts. Question 12. In the scenario where a business dispute arises over the enforceability of an arbitration clause, a consumer sues a telecommunications company for fraudulent billing. The company moves to dismiss the lawsuit, citing a mandatory arbitration clause in its service agreement. The consumer argues that they were not aware of the clause and never explicitly agreed to it. What will the court most likely decide? A. The arbitration clause is enforceable because it was included in the agreement. B. The clause is unenforceable because the consumer did not have meaningful notice or an opportunity to negotiate. C. The company must prove that arbitration is the most efficient resolution method before enforcement. D. The consumer will be allowed to opt out of arbitration at their discretion. Answer: B. The clause is unenforceable because the consumer did not have meaningful notice or an opportunity to negotiate. Explanation: Courts analyze procedural unconscionability when evaluating arbitration clauses. If the consumer did not have reasonable notice or an opportunity to reject the terms, the clause may be invalid. Option A is incorrect because mere inclusion in an agreement does not guarantee enforceability. Option C is incorrect because efficiency is not the primary factor in arbitration enforceability. Option D is incorrect because opt-out provisions must be clearly stated at the time of agreement. Question 13. When a corporation faces regulatory scrutiny due to allegations of market manipulation, the SEC launches an investigation into a hedge fund accused of artificially inflating stock prices. The hedge fund argues that its trading strategies were lawful and that the SEC's investigation is politically motivated. Which legal doctrine is most relevant in determining whether the SEC's actions are justified? A. The business judgment rule, protecting companies from regulatory overreach. B. The Chevron doctrine, allowing deference to agency interpretations of ambiguous laws. C. The rule of lenity, requiring laws to be interpreted in favor of the accused. D. The Noah-Pennington doctrine, shielding businesses from liability for influencing regulations. Answer: B. The Chevron doctrine, allowing deference to agency interpretations of ambiguous laws. Explanation: Under Chevron U.S. A. Inc. v. Natural Resources Defense Council Inc. 1984, courts defer to administrative agencies when interpreting ambiguous statutes within their jurisdiction. The SEC's interpretation of securities laws would likely be given deference. Option A is incorrect because the business judgment rule applies to corporate governance, not regulatory investigations. Option C is incorrect because the rule of lenity applies to criminal law, not regulatory enforcement. Option D is incorrect because the Noah-Pennington doctrine protects lobbying efforts, not market manipulation claims. Question 14. When a multinational corporation expands into a new jurisdiction, it must comply with local labor laws that impose stricter worker protections than those in its home country. The corporation argues that certain regulations, such as requiring a minimum number of paid vacation days, are excessive and hurt business operations. Which legal principle will most likely govern the corporation's compliance obligations? A. The Dormant Commerce Clause, preventing states from unduly burdening interstate commerce. B. The Foreign Corrupt Practices Act, regulating corporate behavior abroad. C. The Principle of Territoriality, requiring adherence to local laws. D. The Privileges and Immunities Clause, preventing discrimination against foreign corporations. Answer: C. The Principle of Territoriality, requiring adherence to local laws. Explanation: Under the principle of territoriality, businesses must follow the laws of the jurisdiction in which they operate. If a corporation expands to a new country, it must comply with local labor regulations. Option A is incorrect because the Dormant Commerce Clause applies to U.S. state laws, not international regulations. Option B is incorrect because the Foreign Corrupt Practices Act deals with bribery, not labor laws. Option D is incorrect because the Privileges and Immunities Clause applies to individuals, not corporations. Question 15. During a merger involving two major technology companies, antitrust regulators investigate whether the deal would create a monopoly. The companies argue that their combined market share does not significantly limit competition. Which test will regulators most likely use to evaluate the merger's impact? A. The Per rule, which automatically deems mergers illegal. B. The Rule of Reason, weighing competitive effects. C. The Parker Immunity Doctrine, shielding companies from liability. D. The Non-Delegation Doctrine, requiring congressional approval. Answer: B. The Rule of Reason, weighing competitive effects. Explanation: Under the Rule of Reason, courts and regulators evaluate whether a merger promotes or restrains competition. The Herfindahl-Hirschman Index H-chart is often used to assess market concentration. Option A is incorrect because mergers are not automatically illegal. They are analyzed for competitive effects. Option C is incorrect because Parker immunity applies to state actions, not corporate mergers. Option D is incorrect because the non-delegation doctrine concerns legislative power, not antitrust reviews. Question 16. If a government agency introduces new data privacy regulations that affect global businesses, how will international companies ensure compliance? A. They must follow the most stringent standard globally to avoid conflicts. B. They can ignore regulations outside their home country. C. They must evaluate jurisdiction-specific requirements. D. They can rely solely on voluntary industry guidelines. Answer C. They must evaluate jurisdiction-specific requirements. Explanation. Companies must assess legal requirements in each jurisdiction where they operate. The General Data Protection Regulation (GDPR) in the EU, for example, applies extraterritorially. Option A is incorrect because compliance depends on specific jurisdictional laws. Option B is incorrect because foreign laws can apply to international operations. Option D is incorrect because voluntary guidelines do not provide legal protection. Question 17. When a company is accused of misleading investors through inaccurate financial reporting, regulators investigate under securities laws. Which statute governs such cases? A. The Clayton Act. B. The Sarbanes-Oxley Act. C. The Lanham Act. D. The Uniform Commercial Code. Answer. B. The Sarbanes-Oxley Act. Explanation. The Sarbanes-Oxley Act 2002 requires public companies to maintain accurate financial records and imposes penalties for fraud. Option A is incorrect because the Clayton Act deals with antitrust issues. Option C is incorrect because the Lanham Act governs trademarks. Option D is incorrect because the Act covers commercial transactions, not securities fraud. Question 18. When a contract dispute arises over ambiguous language, courts interpret the terms to determine the parties' intentions. Which principle applies? A. Contra pro frentem. B. Strict liability. C. Parallel evidence rule. D. Res ipsa loquitur. Answer. A. Contra pro frentem. Explanation. Under contra pro frentem, ambiguous contract terms are interpreted against the drafter. Option B is incorrect because strict liability applies to torts, not contracts. Option C is incorrect because the parallel evidence rule limits external evidence but does not resolve ambiguity. Option D is incorrect because res ipsa loquitur applies to negligence cases. Question 19. If an employee claims wrongful termination based on retaliation, what must they prove? A. The employer violated a public policy exception. B. The employer acted within it with employment rights. C. The employee failed to mitigate damages. D. The employee was an independent contractor. Answer. A. The employer violated a public policy exception. Explanation. Many states recognize public policy exceptions to employment, protecting whistleblowers. Option B is incorrect because employment has exceptions. Option C is incorrect because mitigation of damages applies after termination. Option D is incorrect because independent contractors are not covered by wrongful termination laws. Question 20. When a shareholder challenges corporate board decisions, what standard applies? A. The business judgment rule. B. The corporate opportunity doctrine. C. The fair use doctrine. D. The first sale doctrine. Answer. A. The business judgment rule. Explanation. The business judgment rule protects corporate boards unless decisions involve fraud or bad faith. Option B is incorrect because the corporate opportunity doctrine prevents directors from taking business opportunities for themselves. Option C is incorrect because fair use applies to copyright law. Option D is incorrect because first sale doctrine concerns resale rights. Question 21. When a company implements artificial intelligence in hiring decisions, concerns arise regarding potential discrimination. A lawsuit is filed alleging that the AI system disproportionately rejects candidates from certain demographic groups. Which legal framework will most likely govern this case? A. Title Omen of the Civil Rights Act. B. The Fair Credit Reporting Act. C. The Federal Trade Commission Act. D. The Digital Millennium Copyright Act. Answer. A. Title Omen of the Civil Rights Act. Explanation. Title Omen of the Civil Rights Act of 1964 prohibits employment discrimination based on race, color, religion, sex, or national origin. If AI hiring algorithms lead to disparate impact where neutral policies disproportionately affect protected groups, employers may face liability under this law. Option B is incorrect because the Fair Credit Reporting Act governs the use of consumer credit reports, not hiring discrimination. Option C is incorrect because the Federal Trade Commission Act primarily addresses deceptive business practices, not employment discrimination. Option D is incorrect because the Digital Millennium Copyright Act concerns digital copyright issues, not employment law. Question 22. When an international corporation transfers customer data between countries, it must comply with global data privacy laws. Which regulatory framework is most relevant to ensuring lawful data transfers? A. The General Data Protection Regulation (GDPR). B. The Sherman Antitrust Act. C. The Federal Arbitration Act. D. The Truth in Lending Act. Answer: A. The General Data Protection Regulation (EDPR). Explanation: The General Data Protection Regulation (EDPR) applies to organizations handling EU citizens' data and includes strict rules on cross-border data transfers, requiring adequate safeguards such as Standard Contractual Clause (CCS) or binding corporate rules (ERS). Option B is incorrect because the Sherman Antitrust Act deals with competition, not data protection. Option C is incorrect because the Federal Arbitration Act governs arbitration agreements, not international data transfers. Option D is incorrect because the Truth in Lending Act regulates consumer credit disclosures, not data privacy. Question 23. When an employee resigns and joins a direct competitor, their former employer sues, alleging a violation of a non-compete agreement. Which factor will most likely determine the agreement's enforceability? A. The geographic scope and duration of the restriction. B. Whether the employee received company handbook. C. The employee's personal preference for career advancement. D. Whether the employee verbally agreed to the restriction. Answer: A. The geographic scope and duration of the restriction. Explanation: Courts evaluate non-compete agreements based on reasonableness, considering geographic scope. A local restriction is more likely enforceable than a global one. Duration: shorter periods are more enforceable. Legitimate business interests, such as protecting trade secrets. Option B is incorrect because a company handbook does not determine non-compete validity. Option C is incorrect because employee preference does not override legal analysis. Option D is incorrect because non-competes must typically be in writing to be enforceable. Question 24. If a company engages in price-fixing agreements with competitors, what legal consequences could it face? A. Criminal prosecution under antitrust laws. B. A minor fine with no long-term effects. C. Protection under free market principles. D. Exemption if the agreement benefits consumers. Answer: A. Criminal prosecution under antitrust laws. Explanation: Price fixing violates the Sherman Antitrust Act and is subject to criminal penalties, including fines and imprisonment. Option B is incorrect because penalties can be severe, including multi-million-dollar fines. Option C is incorrect because free market principles prohibit anti-competitive agreements. Option D is incorrect because agreements that fix prices are illegal regardless of consumer benefits. Question 25. When an online retailer misrepresents product specifications, customers file lawsuits claiming deceptive marketing practices. Which law is most relevant to these claims? A. The Federal Trade Commission Act. B. The Clean Air Act. C. The Bankruptcy Code. D. The Uniform Commercial Code. Answer: A. The Federal Trade Commission Act. Explanation: The Federal Trade Commission Act (FTC) Act prohibits unfair or deceptive business practices, including false advertising. The FTC can impose fines and require corrective actions. Option B is incorrect because the Clean Air Act regulates environmental standards, not consumer protection. Option C is incorrect because the Bankruptcy Code deals with financial insolvency, not false advertising. Option D is incorrect because the Uniform Commercial Code governs sales contracts, but false advertising is an FTC issue. Question 26. If a pharmaceutical company hides safety risks of a new drug, what legal consequences might it face? A. Liability under the False Claims Act. B. Protection under trade secret laws. C. A minor fine with no criminal liability. D. The ability to claim product liability immunity. Answer: A. Liability under the False Claims Act. Explanation: Under the False Claims Act (FCA), companies that misrepresent product safety, especially when government reimbursement is involved, can face civil and criminal penalties for fraud. Option B is incorrect because trade secret laws do not protect fraudulent concealment. Option C is incorrect because FCA violations often involve severe penalties, including treble damages. Option D is incorrect because product liability immunity does not cover intentional fraud. Question 27. When a social media company restricts content, users claim violations of free speech rights. Which legal principle governs the company's actions? A. The First Amendment applies only to government actions. B. Private companies must protect all speech equally. C. The company can be sued for violating users' constitutional rights. D. Content moderation decisions require government approval. Answer: A. The First Amendment applies only to government actions. Explanation: the First Amendment only applies to government restrictions on speech, not private platforms. Private companies can moderate content as they see fit. Option B is incorrect because private companies have broad discretion over speech. Option C is incorrect because users cannot sue for First Amendment violations against private companies. Option D is incorrect because government approval is not required for content moderation. Question 28. When a business engages in unfair labor practices, employees file complaints with the National Labor Relations Board (NLB). What type of violations does the NLB investigate? A. Employer retaliation against unionizing efforts. B. Tax evasion by corporate executives. C. False advertising about product safety. D. Discrimination under Till Roman. Answer: A. Employer retaliation against unionizing efforts. Explanation: the NLB enforces the National Labor Relations Act area protecting workers' rights to organize, bargain collectively, and protest unfair labor practices. Option B is incorrect because tax evasion falls under RIARA's jurisdiction. Option C is incorrect because false advertising is handled by the FTC. Option D is incorrect because Till Roman applies to educational institutions, not labor law. Question 29. When a company collects biometric data from employees for security purposes, concerns arise about privacy violations. Which legal regulation is most relevant to governing this practice? A. The Illinois Biometric Information Privacy Act, BIPA. B. The Sarbanes-Oxley Act, SOX. C. The Foreign Corrupt Practices Act, FEPA. D. The Occupational Safety and Health Act, OSHA. Answer: A. The Illinois Biometric Information Privacy Act, BIPA. Explanation: the Illinois Biometric Information Privacy Act, BIPA, requires companies to obtain informed consent before collecting biometric identifiers, fingerprints, retina scans, facial recognition data, and to implement security measures. Failure to comply can result in significant lawsuits. Option B is incorrect because the Sarbanes-Oxley Act addresses corporate financial reporting, not biometric data. Option C is incorrect because the Foreign Corrupt Practices Act, FEPA, targets bribery and international business, not privacy issues. Option D is incorrect because OSHA regulates workplace safety conditions, not biometric data privacy. Question 30. When a company sells a defective product that causes injuries, customers file lawsuits for compensation. Under which legal theory can the company be held liable? A. Strict product liability. B. Respondit superior. C. The Clean Water Act. D. The Fourth Amendment. Answer: A. Strict product liability. Explanation: strict product liability holds manufacturers responsible for defective products that cause harm regardless of negligence. Liability applies if the product was defective when sold, the defect caused injury while used as intended, the product reached the consumer without substantial changes. Option B is incorrect because Respondit superior applies to employer liability for employee actions. Option C is incorrect because the Clean Water Act regulates environmental pollution, not consumer injuries. Option D is incorrect because the Fourth Amendment protects against unlawful government searches, not product safety.